Yeah, well, it's sort of
Everyone
the
has
same
their
as mine.
cups.
Yeah,
Very
I
good.
think I'm gonna-
Good afternoon. I'm Jeff Fisher. I'm a past board president of the 9th Judicial Circuit Historical Society and still serving on the board after many, many years. On behalf of the Society, I want to welcome everyone for coming today, another terrific crowd. We're so happy to have you here with us today. We'd like to extend a special welcome to the judiciary, judges of the 9th Circuit, Northern District Court, and to our new friends, the judges of the CPUC. We're also thrilled to have many court family members here with us today, as several of our board members and advisory council members, including Rob James, Andrew Ong, Nora Puckett, and Lillian Tsai. These programs, like the one today, take a village to put on, and so we'll thank everyone at the end of the program. But for now, just a quick note about our program partner today, the Berkeley Judicial Institute, and to our wonderful sponsors, Thomson Reuters, and also the National Judicial College, represented here today by Joy Lingar. We're so appreciative of the partnerships and the supports as we look forward to this important topic in the discussion today. And before we begin, I want to introduce you to the Executive Director of the 9th Circuit Historical Society, who has put on this program and countless other programs, and it's just our deepest gratitude for all you do, Robin. Robin Litsky.
Thank you. Jeff, and thank you for those of you who are not already members, and I hope by the end of the evening there won't be many of you left who can say that. We are a nonprofit organization whose mission is education about the vibrant legal history of the West and also the importance of an independent judiciary. We accomplish our mission through taking oral histories of judges throughout the 9th Circuit, through traveling exhibits, through our journal Western Legal History, and through programs like the one today. For those of you who would like to support our mission, we have a special membership goodie bag and our light-up pen. Exactly. Illuminating history. And you can see our assistant to the director, Scarlett, after the program if you'd like to become a member. And I also highly recommend our newest issue of Western Legal History, our journal, which is full of very engaging articles about the long road to women's suffrage in the West. But for now, I would just like to introduce our moderator for today, Judge Jeremy Fogel. Well, I could probably take up a large portion of the program introducing Judge Fogel. In the interest of time, I'll simply say that in September 2018, Judge Fogel became the first executive director of the Berkeley Judicial Institute, whose mission in part is to promote an ethical, resilient, and independent judiciary. Prior to his appointment at Berkeley, Judge Fogel served for 7 years as director of the Federal Judicial Center in Washington, D.C., and before that was a judge of the United States District Court for the Northern District of California, and also before that a judge at Santa Clara Superior and Municipal Courts. For so many reasons, we are thrilled to have him here today to moderate our program with his fellow panelists, who he will introduce further. California Court of Appeals Justice Stewart, who is very kindly filling in for Martin Jenkins, who is called away to another event. Stanford Law Professor Pam Karlan, and LA Times legal affairs writer Maura Dolan. So thank you so much.
Thank you, Robin. And I am just so happy to be here. It's great to see so many friends, and just to be in this wonderful space and to be talking about this topic. It's really about as important as anything that's affecting the judiciary and the legal profession these days. I'm very privileged to be sharing the podium with three people who have a lot to say, a lot to offer to us about the topic of courts and the media. To my right is Pam Karlan, who, as Robin said, teaches at Stanford Law School. Pam has been an advocate before the U.S. Supreme Court. She's done just a ton of really significant litigation on behalf of civil rights and human rights and constitutional rights of all kinds. Great teacher. Worked in the Justice Department for a time during the Obama administration. Really has seen some of the things we're going to be talking about firsthand, and will be giving us the benefit of that experience. Justice Therese Stewart, and I want to thank her for filling in for Marty Jenkins at the last minute. Marty, thought he was just going to be appointing judges, but he's a member of the governor's senior staff, and I guess when the state's on fire and things like that, he gets called to meetings that have nothing to do with judges, and so that's part of what's been going on with him lately. but thank you very much for filling in. And pretty darn good fill-in. She practiced law for 20 years with the Howard Rice firm here in the city, was with the city attorney's office as the number 2 for a dozen years before going on the first District Court of Appeal. Many strong accolades in her resume, including, of course, the same-sex marriage cases in California. So we're really happy to have her. And then someone who I have a particular sense of connection with because we intersected on a couple of cases that meant a whole lot in my life, but a vanishing breed. Maura Dolan has been a legal reporter for almost 30 years. There are hardly any legal reporters anymore, and she still is one for the LA Times organization, and a very good one at that. And we're happy to have the benefit of her experience because, among many other things, she can tell us how the profession of journalism has evolved, and in particular has evolved in the way that it covers the law in the courts. So welcome to all of you. And let me actually start with Maura Dolan. So you have been a journalist a long time. And I know even the cases that we were involved in together, you were very much the way we think of journalists traditionally. It was like get the story, get the facts, do the research, write articles that were in depth, that really explained cases or explained the context of cases. So how has that changed?
Well, we still do that, but on deadline, it's tough because before, when I first started out, I was covering the California Supreme Court, and you'd get maybe an 80-page opinion, and you'd have a few hours, sometimes several hours, to write a story about it, and I would have time to call the lawyers and get their take to understand it. Now we write for the web, and if it's a big story, they want it within 15 minutes. So you look at a court opinion. Obviously, you're trying to get the result. You figure out what the result is. If there is a dissent, you look there because the dissent is often very helpful in explaining the decision. And then you have to hit go. And it's really nerve-wracking. I mean, I've been doing it a long time, and I'll know this, I'm right, I know this is, I've got this down. And I still hate to hit that button because just in case it's so quick, I haven't read the whole opinion. I've just read little snatches. And then you update it throughout the day, which is fine because then you have more time to read it and you get quotes. And then the very last part of the day, you can also be interviewing other lawyers and experts. Pam Karlan, I used to interview you when you were a lawyer for stories. But it's a much more nerve-wracking job, and you're supposed to write. You're starting to write before you've read the whole opinion, and there's social media too, which so the job is much busier. You're working on one story all day, continually rewriting, and then you're also filing social media. You're tweeting the stories. And that's new to me. I'm older. I didn't grow up with social media. And we were always taught, obviously, to be completely objective. You don't want anybody to know your opinions. And I'm still very careful. There's stories that I think I would like to retweet because they're interesting or they said something new, but I won't do it because they have a point of view, and I'm afraid others may think that, I share that point of view. And the other difficulty with the internet now is oral argument. We cover oral argument, and the test is to try to predict how the court is going to rule on a decision. And we use all this, language, appeared to, seemed to, wiggle language, but still, you have to make up your mind pretty quickly, and you're kind of reporting and writing at the same time you're listening to oral argument. And there are things you can do in advance, obviously. You can call people like Pam or somebody to get analysis beforehand. You read all the briefs. I mean, I've even done things like written the lead several different ways, depending how the court ruled. It's not the best way to do it, but you can get it up accurately and fast.
I was at a program at the museum a couple years ago where there was a legal reporter for a paper on the East Coast who said that one of the things that had changed the way he covered stories was that part of his evaluation for pay raises and things like that was how many clicks he had received on his articles.
Well, thank goodness the LA Times doesn't do
That's
that.
good. That's good to hear.
Being a legal affairs reporter, I wouldn't get nearly as many clicks as some of the other reporters. But
is that
no.
a problem in journalism?
Well, they do want
Yeah.
clicks.
Yeah,
They do
yeah.
want clicks. When I was covering same-sex marriage, I got a lot of clicks. But, there are other much more boring legal disputes that I cover, and I don't get a lot of, people don't pass it around. And on Twitter, too, I think my job is a little bit different because I don't see judges on Twitter. I mean, you can get reaction on Twitter, but it's, the younger reporters use Twitter to find people. They're very good at it. There's a disaster or shooting, something, and they get on Twitter and somebody will comment and they'll track them down. It's an excellent resource for reporters.
So what I'm hearing is at least your paper is supporting you in the sense of journalistic ethics and doing a good job in getting the story right. It's not about whether your stories are clickbait or not,
No.
but that everything is accelerated.
Fast.
It's
Yes.
much more accelerated than it used to be.
Much more accelerated. Your day is so busy compared to the way it used to be. Rewriting. In your first version, sometimes you'll see what I first put on. I mean, I'm almost embarrassed. It's bare bones and maybe not the best written. That by the end of the day, it looks pretty good. But you're just trying to get it out there. And also these opinions, trying to find a good quote out of them can be very challenging.
Especially with some judges, right?
Some judges, some are better than others. The dissents often are more quotable than the majority opinion.
Okay, so Pam, you've and I have a number of different contexts I want to ask you about, but one of them is that you have been an advocate at the Supreme Court, and they have a bar, and they have a press that if you go to an argument at the Supreme Court, they're sitting there. Have you seen changes over time?
So,
Yeah.
there are basically two groups of reporters who are or maybe even three groups of reporters who will be covering a Supreme Court case. There's the Supreme Court press corps. Nina Totenberg announcing that a decision is expected by June. David Savage from the LA Times, Adam Liptak, Marcia Chambers, folks like that. They're all pretty expert at covering the court, and they don't have anything else that they have to do generally. They're just covering the court. So they can spend a lot of time in the lead up. So you'll spend a lot of time in cases talking to them ahead of time. They're putting together their stories, doing the interviewing and the like. There's a second group of reporters that you deal with sometimes at the Supreme Court who are specialists in whatever the issue is that the court is covering, but they're not really experts at covering the Supreme Court. So some of the business press is like that in particular. And then there are the random reporters from the hometown of whoever the case involves. And they often don't know anything about the court or about the law. And so it's a little bit like, for those of you who have gone to a Passover Seder, the four kinds of kids. There's the wise kids, the wicked kids, the simple kids, and the kids who don't even know what to ask. And that's kind of what the range of reporters you're dealing with is. You're dealing with, David Savage, he has read every Supreme Court case in the last 15 years, so you can talk to him in some depth. Then there are the scoffer, the people who are writing for a part of the media that we haven't really discussed yet, which is the rise of a kind of advocacy media online of people who are very opinionated, and you have to be very careful with some of those folks, what you say or you don't say. Then there are the ones who just don't understand what you're doing. And then the final thing is, and my colleague, the other Jeff Fisher, wrote about this recently, is the rise of lawyers who have cases in front of the Supreme Court, blogging about the cases, writing things after the oral argument saying would've, could've, should've, and the like, and that, this sort of what's come to be known as virtual briefing, is another piece of the media that's out there. So the ecosystem has changed dramatically from the days in which, you'd get one story written in each of the major papers about the case that would come out the next day. And just one thing, I know we're going to talk later about cameras in the courtroom, but I think one of the reasons why the Supreme Court does not release the audio tapes of the arguments until the end of the week is they don't want that stuff being turned into very fast stories coming out right after the case, because they're worried about how people will edit the tapes.
The same speeding up dynamics
Yeah,
would
exactly.
affect the way they report. And I gather that you see the same thing. Tony Morrow, who recently semi-retired from the Supreme Court press corps, said that was something he had seen, is the acceleration of the, you've got to report it right now.
And the economics of newspapers
Yeah.
has changed dramatically because they don't have the classified ads anymore, which was where they made their money. The upshot of which is you see fewer and fewer legal affairs reporters, and even sometimes when they are legal affairs reports, they don't have any legal training. And that's a big change from the days when you had, Tony Lewis or, folks like that reporting on this.
The classic, of course, was the misreporting of the Affordable Care Act decision, right? That in their rush to get it out, they
But that's because that's in part a function of how the opinion's written.
Right.
And the same thing was true, I think, last year with the census case, which many of you are familiar with, where, 80% of the way into the case, you thought, I can see where this is going. And then at the last minute, it was kind of,
You mentioned something, and both you and Maura I'd like to ask about, and then I'll turn to Terry for her reactions. But I remember when I was practicing, and certainly when I was a judge on the state court, we had 2 legal newspapers in San Jose, right? And all they did was report the courts, and they were local. Then they kind of got gobbled up by other people. And then the Mercury News, which was the only newspaper in town, had a state court reporter and a federal court reporter. So there were a lot of, and they, for the most part, knew what they were talking about.
Right.
And that's just completely disappeared.
There always used to be a Ninth Circuit reporter and a California Supreme Court, and now I do both. And I don't really think there's anybody assigned to the State Court of Appeal. We'll,
Good.
Yeah, right. If there's a good decision or interesting decision, somebody calls us about it, we'll do it. Particularly out of LA, they'll do more of the Court of Appeal decisions. But we missed some good ones.
That's okay.
So, Terry, how has it affected? You've been a judge. You've been a public lawyer. You've been a private lawyer. How has this change in the journalism profession, at least as we knew it a generation ago, how has that affected?
Well, I think what I am seeing, and I've seen some of it from the outside in and some of it from the inside out, is it's not that there have not been attacks on judges or criticisms in the press or even efforts to challenge judges who are running for election. But I think what Maura mentioned about the speed of the internet and of the way even mainstream media are expected to comment on pending cases has played a real role in sort of the threat that's posed to an independent judiciary. And the case about which people know the most, I think, on this front, but still maybe not all, is the Persky case. And I want to talk a little bit about it just to demonstrate what I mean by there were a combination of things. The 3 things I think were the speed with which certain coverage happened, in which ended up being the people who were critical of the judge, where the forces who were supportive of the judge were not able to act as quickly. Secondly, there was the person who was determined to drum this judge out of office was, to put it kindly, a zealot on the issue and indefatigable, and whether you agree or disagree about the judge's decision, this was somebody who was very sophisticated and knew how to take advantage of that speed, that relative coverage disadvantage of the judge and his supporters, and get the jump on it. And then finally, there was the overlap of the recall effort and the the trial itself, but especially post-trial with the Me Too movement and the kind of viral coverage of things in the wake of that. So just to give you a quick timeline, so the defendant, who was a Stanford freshman, was accused of sexually assaulting a young woman who wasn't a student but was on campus at a frat party when she had essentially passed out from drinking too much. He had also drunk a great deal. Rape charges were initially filed but then dropped because there was no forensic evidence suggesting that of any semen in the woman's body, but there was forensic evidence of her DNA under his fingernails. So the charges that he ended up being tried on were for sexual assault involving penetration, digital penetration. So there were, witnesses on both sides, including him and the victim and the SART exam person and everything else. And it was tried in 2016, and he was convicted of 3 charges relating to this event. The trial was covered by the local press. It was covered, actually, when I read it, pretty fairly, not, outrageous. I mean, there was clearly sentiment on both sides, which was picked up, but it was somewhat balanced. But then the judge did the sentencing, and as he had apparently done, and it was later came out throughout almost all his sentencing, he followed the probation department's recommendation. The sentence was therefore 6 months in jail, and then he had to register as a sex offender for life, which I think was mandatory. And that was what led to the next few things. But basically on the same day, the woman, the professor at Stanford, whose name was Dober, took the victim's statement, which was quite sympathetic and thoughtful and passionate, and gave it to the press. The Mercury News, the same day as the sentencing decision, published a piece, an editorial, saying the sentence was too light. BuzzFeed published the victim's statement. In the ensuing couple of days, Dober also published a letter the father of the defendant had written to the court, which was about the dumbest letter you could ever imagine doing for your kid. Don't do this if your kid is ever in trouble, in which he basically said something along the lines of, he's already paid a heavy price for 20 minutes of action. And it's just like, really? So that didn't help, but she got that to the press. And basically there was sort of endless coverage of these events. And Dober announced almost, within a week or so of the decision that she was going to launch a recall effort against this judge. Needless to say that by the time, and the recall effort took really a couple years because he was up for election in 5 days and there wasn't time to challenge him. So it was, but over the time period that the recall election was then being litigated with constant press, and he did get some supporters together who were advocates, but it was like playing catch up and trying to defend him. And it was a hard thing to defend in this day and age because it was a light sentence in the scheme of things for a sexual assault. But, there were also things you could say about it, about the fact that the victim had no record, about, it wasn't violent, even if it was a horrible taking advantage of this young woman, et cetera, et cetera. But they were behind and they didn't catch up. And there was a petition on change.org that gathered, I think in the end, 1 million signatures. They gathered sufficient real signatures for the recall. It was on the ballot. It's on the ballot in 2018. Meanwhile, what happens? In October, Ashley Judd accuses Harvey Weinstein of sexual misconduct in a New York Times story and I think a New Yorker story. Then there's a series of Me Too moments that basically start getting press. And there were the gymnasts and the doctor who assaulted them. There were the people who accused Roy Moore of preying on young underage women. There was CK. There was Matt Lauer, who's fired. There was Russ Simmons stepping down from his company. There was Al Franken resigning from Congress. And Mario Batali, yada, yada. You remember these things. So that's going on through all of the end of 2017, all the way through to May of 2018 and beyond. And the recall election is in June of 2018.
And I'm watching this from Washington, D.C., and this is my county. And one of the things that just fascinated me, and I really would, is that we could take this very troubling story and kind of expand it into a larger set of lessons, is that there was a meta-narrative that completely obscured the traditional story. And you know, if you look at the recall was successful, I think the vote was about 60 to 40%. The breakdown of the vote, at least from the polling that was done, showed that the votes to recall Judge Persky came from Palo Alto and you know, the wealthier parts of Santa Clara County, and that it was sort of basically liberal Democratic areas that were very upset about Me Too, that used that was the meta-narrative, you know, and that I would say, just my own editorial comment is, not only did the defenders not ever catch up, but they didn't know what hit them.
Right.
You know, that they were talking about, and I think this is where we could kind of expand this a little bit. They were talking about judicial independence and the role of a judge and following probation report. And
Boring.
And the conversation is about Me Too. And they never engaged.
Right.
The defenders never engaged that. I'm not sure that they could have or how they could have, but it was a real. I remember looking at it and saying, when are they going to talk about sexual assault? You know.
Right.
And so, anyway, Pam, you were there. You were at ground zero. What do you think?
Yeah, I mean, my view of it is, yeah, and you've kind of gotten a little bit of a sense of this, that the old saying about, you know, a lie gets the whole way around the world before truth puts on its boots is more true today than it was even in the past. So some of the things that handicapped the people who thought, as I did, that the recall was a terrible idea, and who think that our criminal sentencing tends to, if anything, err on the side of sentencing people for too long rather than for too short a period of time, and who think that there's expertise in the probation office in figuring out that really, you know, this sentence was not out of line with the kinds of sentences that are given to first offenders without long prior, you know, for this kind of offense, is that it's very hard to explain that. That is, if you recognize complexity, you are always at a disadvantage against people who say things are simple. And that's even truer now than it was before. What worries me about this case, in a way, is the effect going forward, because when I first came to California in the 1990s, I did a lot of continuing judicial education stuff for CJUR, because I had worked in a program that did master's degrees for state appellate judges, so I'd gotten to know a lot of federal and state appellate judges around the country, so I do a lot of these things like CJUR. And I was talking about judicial elections, because that was something I had litigated a lot of before I went into teaching. And every judge in the California system was totally hinky about Rose Bird, and that had happened 20 years earlier. And what worries me about things like the Persky event is this could happen to any one of a wide variety of judges who issue sentences. And what do you do to avoid this? You give a harsher sentence. I mean, there's been some interesting empirical work done suggesting that judges who are elected tend to sentence more highly in the year before they come up for re-election. And that shouldn't affect a defendant's sentence at all. But talking about those things is complicated. And on the other side, what you have is outrageous behavior by this freshman, and badly worded defenses of him. That is, when his father said what he said in the letter, I think the charitable reading of that is what Brian Stevenson often says, which is no person is the worst thing they've ever done. So if you look at the worst 20 minutes of anybody's life, we should all be serving life sentences. but that's not who we are. But the way the father put it made it look as if he was actually saying 20 minutes of sexual action. Why should my son pay any price for this at all? Which, of course, is incorrect. Of course, he should pay a price for it. The question is, what should that price be? And it's just very hard to explain these things. I mean, a group of Stanford law students went through and did a thorough researching of Judge Persky's sentencing opinions and decisions, and then compared them to the sentencing decisions of other judges to show that his sentences were well within the mainstream of what other judges had done. But nobody really covered that because it wasn't gripping in the way that the stuff that Michelle Dauber did, which is she's a master at exploiting the kind of, the seams in the media to get stuff covered in a way that's really quite misleading.
Yeah. So Maura, let me turn to you. So you're down.
I did cover that.
Yeah, you did cover
I
it.
did
So
cover
what
that.
were your observations?
Well, I have never been,
Yeah.
well, I have been, I'm sure, but browbeaten by that woman. She's a very strong advocate, believes in what she believes, but, I know another reporter for the San Francisco Chronicle, and she quibbled with something he had, and he ended up spending 10 hours with his editors going back and forth. She was a fighter, just incredibly combative. I did write a piece that did talk about Persky and talked about judicial independence. But I write for the LA Times, and most readers for the LA, I was not writing for a local audience. And it was interesting because the women, they were all women on the side of Persky, women, Doris Cadell, and Santa Clara University law professor, liberal women trying to save him, and then this other group who considered themselves feminists as well, trying to send him down. And after this, there was a case, the Ghost Ship Fire case. Mm-hmm. Some people think that this judge was Persky'd. That there had been a plea agreement. Are you familiar with the Ghost Ship Fire case? Probably everybody is. Okay. There had been a plea agreement in which these two defendants were going to serve, I don't remember how many years, 4 years or so. And the judge who had the case was out this day. Another judge came in. They heard from the family who really complained about it, and he threw out the plea agreement. And of course, when it went to trial, one of the defendants got off completely, and the other defendant, it was hung. But people thought that this was, I don't know. I don't want to impugn his character at all, but people thought that this was one of the results of the Persky case. And he also just lost his job as a tennis coach, right?
Yeah.
Right. Well, I gather that's because the same woman has basically relentlessly...
He's in a way, and I say this with some guardedness, but I mean he's being treated as if he was the perpetrator.
Right.
I mean, he's being ostracized in the same way.
Right.
Yeah. So this is this case. We could talk about this case all night, but I mean it's an example of some of the challenges the judiciary and the media face in trying to represent some form of truth. Trying to explain things that happen in court is complicated. And sometimes it's not that interesting, I mean, it's just, and yet if you don't do it, then you can kind of get these runaway trains.
And it was kind of the perfect storm.
Yeah, it was. No, it really was. I mean, I think. So what are some strategies that we could talk about, and we can invite some questions from the group too. But what are some strategies we can think about? How do we get the message of the judiciary out? How do we use the resources that the media still has, the professional media? I'm not talking about social media or bloggers. So, what can we do that we aren't doing now?
Well, I think there's a very long-term solution and then a bunch of shorter things.
Mm-hmm.
The very long-term solution is, and Justice O'Connor, I think, has this exactly right, is that we need to return to an idea of civics education in which people actually learn about what the courts do without focusing on a particular case. That is, one of the things that they've discovered is people who serve as jurors in courthouses where the jury room is not an absolutely disgusting pit come away from the experience, people who actually get to serve on the juries, with a much better opinion of courts. People who go to see arguments come away with a much better experience. So, classrooms in the courthouse programs and the like. Because in the long run, either people will have a commitment to judicial independence as a kind of fundamental piece of American law, or they won't. If they don't have that, no amount of the media talking about it in the context of a particular case is going to change things. But that's a very long-term solution. And there are lots of things, obviously, that lawyers can do, and that the courts can do to bring the courts to the people and give people a better sense of what courts actually do. In a weird way, I think some of the backlash to the president's attacks on the independence of the federal judiciary may have a little bit of this effect. That is, people are now actually seeing why it matters so much that you have judges who are independent in a way that I think people weren't really thinking about, say, 5 or 10 years ago, because the system seemed to just kind of run on its own. And now when you have, judges being attacked by the president and the Chief Justice of the United States thinking it's important to come in and say, there's a reason that judges do what they do. I think that's really important. I think some more investigative reporting into what happens when people like Michelle Dauber hijack a case would be useful as well. That is, so much of the press, the press, I don't mean the press, the media, I mean the press of events and the pressure of time lead to he said, she said as a way of reporting every story. There are two sides to every story, so you should report them without any real evaluation. I think that has consequences. If you say, somebody makes this claim, somebody else makes this claim, and you think about the back and forth on the New York Times reader ombudsman about should they say the president has lied or not. Well, if the media is simply going to report everything as one person says this and another person says that without any evaluation of what's going on.
I mean, part of the problem, though, is that judges can't immediately respond either themselves, and it takes a while for them to get others who can. And if you have somebody who's putting things out in the press and that are getting, going viral, pieces of evidence, what have you, it's very, very difficult. The CJA, the California Judges Association, has a response to criticism committee, and they will speak out and write out in support of judges, but the judge who's been attacked has to decide they want that to happen. And it's difficult because sometimes having them speak out just prolongs the debate.
Yeah, although, so a couple thoughts on this. Judge Jim Robart in Seattle, who was the so-called judge in the travel ban case, and received a couple dozen credible death threats and needed 24-hour protection. He got over 1 million hostile emails and tweets. And I have known this guy for 15 years, and believe me, it changed his life. It was traumatic. One of the things that he's doing, which I give him incredible credit for, is he is going out and speaking to groups like this about what happened to him. I mean, he's humanizing it. He's not talking about the travel ban case. He's talking about what happens when a judge is subjected to that kind of attack. And I think that one of the things I think is missing, and I agree with what Pam said about civics education, but it is long term.
Yeah, it's very long term.
And the thing that we don't really see very much is, well, who are these judges anyway? What do they look like? What do they sound like? What do they do? And there are opportunities, even when you're sitting, and certainly when you're retired, but when you're sitting, as long as you don't talk about pending cases, I mean, you can humanize yourself and project yourself out in the community. So there was a good story, right, in San Francisco.
Yes, but I'm going to be a little provocative about it because,
Yeah.
frankly, I don't think it was necessarily about, effective use of the press or of education or of any of the things we've been talking about. It was good old-fashioned politics. So I'm sure most of you know 4 San Francisco Superior Court judges were challenged, not in a recall, but they were up for their every 6-year election And they were challenged by 4 deputy public defenders who started out by saying it was because they were appointed by Republicans. Of course, 3 of them were lifelong Democrats, but hey, who cares? Then that was about the need for diversity, even though 2 of them were Asian American. And if you looked at the history of the judges' actions, there was not only no hint of bias, but a good deal of work that they'd done either in practice or on the bench that reflected a real sensitivity to issues about race and gender and things like that. Then they started saying, well, it's really about bias, but they couldn't establish it. They accused one judge, Karnow. They took one decision in which he ruled in favor of a landlord against a tenant and said he was biased in favor of landlords, even though there were other decisions that he had decided in favor of the tenant. But what they did that worked was, number one, they called my former boss, the city attorney, for help, and he told them, you have to hire this political consultant. We convened a group of past presidents of the Bar Association who basically, those who weren't judges, went out and raised money for the campaign. I guess in theory we could have, but it wasn't comfortable. But in any event, plenty of them were lawyers, raised a bunch of money to pay the darn consultant. The consultant went out and got endorsements from every local political leader that he could and sewed them up early. Fortunately, unlike the Persky situation where there was a very sophisticated opponent, these public defenders had not really run for anything before and didn't really know what they were doing. And they didn't, there's debate about how much their boss, the public defender at the time, and my former friend, Adachi, had to do with it, and he certainly knew how to run, but he wasn't trying to run their effort, even if he was supportive of it. And in the end, basically, they fought a political campaign. And one of the things as a judge you are allowed to do in California is you can speak out on judicial elections. And so I went to the DCCC, which, a lot of judges are like, A, what's that? And B, what do we do with it? And because I had been working for local government for a while, I had some familiarity and I knew a lot of the players. And we brought other folks who did, and we made a really hard push to get their endorsement. And it wasn't so clear in the beginning that we would, but we did. So in the end, they won, and I would call it somewhat of a landslide. The sitting judges won anywhere from 55 to 65% of the vote as compared to the challengers getting 26 to 44%. By the way, the one that did the worst was Karnow because of that tenant thing, I think. But it really, they were a little bit like doe in the headlights about raising money, about having a consultant, and you kind of would like them to be. And as Pam said earlier, the real thing is not these 4 judges, although they are amazing people and they totally deserved to stay on the bench, but about the in terrorem effect that this challenge had on the rest of the judges on that court and beyond. I want to say one more thing, that very much more recently, several months ago, a former colleague of mine who's now a Superior Court judge, whose name is Christine Van Aken, was criticized for a decision in which she granted bail to a man charged with, I believe it was a misdemeanor assault on a young woman who was not injured, and he had, I think, a petty theft. It was his only record, no other violence, and he had mental illness, and she released him I believe it was at the suggestion of probation, but I can't recall, but without bail, because bail is now sort of not okay in our system, thanks to my colleague and some others. She put conditions on it that he had to report to a mental health counselor of some sort in the system. But what happened was somebody the next day, the woman who'd been assaulted and was angry that he was released, and put out on the internet, and it went viral, this video of the incident. And the video had never been presented to the court. The DEA hadn't done that. I guess they don't really put their cards all out there at the bail hearing. And so Christine hadn't seen it, and she fortunately was somewhat sophisticated. She held a hearing when she saw it out there in the public domain, and she can't speak to the press, but if you hold a hearing in a highly publicized case, guess what? The press shows up. Good thinking. And then my former boss, the city attorney who she worked for, also put out a statement early. But we don't know for 2 more days whether someone will challenge her based on that. Probably, hopefully not, but those same public defenders whose issue this isn't, by the way, may yet do so. So one worries.
There's a lot in there,
Right.
in what you said. I mean, about sort of the perils that elected judges face, particularly in the internet, social media age, but also, I mean, just what it took to mount an effective response. That it took old-fashioned politics, right? So, I mean, how do we feel about that? I mean, is that being?
Well, that's what I mean by provocative. I mean, you're saying, we got to educate people, we got to, and we do. All of the things that have been said here are important. But I think in the end of the day, either you have to not have elections, or you have to space them further apart, but you also have to get rid of the recall, or you have to put limits on the recall. So there's just in our state system, the federal system at least has life tenure, which you may or may not want for state court judges, but having these every 6-year elections for Superior Court judges and the possibility of a recall is really threatening in this environment.
One of the cases that Maura Dolan and I share was the attempt to recall Governor Davis, in 2002, the successful attempt to recall Governor Davis. But what people forget is that actually almost didn't happen because there some precincts had been rearranged, and you still needed Section 5 pre-clearance then. It was before Shelby County. And I had issued a TRO because they didn't have pre-clearance, and they came within about 6 hours of not making the deadline. And I was getting hate mail throughout saying, and one of them was, I just love this letter. I kept it. It says, "I'm never voting for you again."
Okay.
And I said, "That's true, you're not. The benefits of life tenure." So so Maura, how do you, this? I mean, I think this is provocative. I think it's a conversation we have to have. Mm-hmm. And how do you, as a journalist, think about this? If you're trying to report a story and you're trying to be fair and accurate as to what's going on in a controversial case, can you get into this kind of detail? Do you have the opportunity?
We can.
Yeah.
We can.
Yeah.
I mean, I did that. I mean, it was a weekender for the Persky case. I did one piece.
Yeah.
But I interviewed several law professors, and in fact, the Stanford was the lead one. She actually was a professor who was upset by this sentence. She thought it was too light. But she said to go after the judge is absolutely the wrong decision because judges tend to be too tough, not too light, and it's going to encourage tough sentences. And I interviewed, obviously, Michelle Dauber. There were things in that campaign that came out about her background, her personal background, that became a debate among journalists and editors whether they were relevant or not. I mean, she had some history that you could say made her very sensitive to this topic. But I mean, it was tough. It was a tough thing to cover. And both sides are so passionate. And Michelle Dauber is a force. I mean, I remember talking about judicial independence, and she'd say, well, judges are election. This is just an election. If you can elect them, we can recall them. So, and there were signs everywhere on the lawns, and the judge looked horrible. The defendant who was convicted and sentenced to 6 months looked like a maniac in the photographs. It was very, we do try to put this in focus.
But there's only so much you can do, and there's this whole world kind of swirling around above.
And we get criticism, too. I mean, when I wrote about same-sex marriage, some of the most vile emails, I asked to get my email taken off from the from my stories, and they wouldn't do it. And the other one was not so much anymore, not gay rights now, it's more accepted. Capital punishment was the other one where you'd get just vicious comments and emails, and threatening, really.
Yeah. So I want to just go into one more topic, as we said we were going to, and it's always one that stirs up controversy in this, cameras in the courtroom. But I want to just mention, the Chief Justice, about 2 months ago, made a comment about there's no Bush judges, there's no Obama judges, et cetera. And you can pick that comment apart, and you can say it was too mild, you can say it was too late, but this for this particular chief was an unbelievably radical moment. I mean, he is one of the most cautious people that I've ever met, and just avoids politics, at least explicitly in any way that he can. And for him to make that statement, he had to be really worried. So make what you will of that, but I just think that's a piece of context. Now, into that context, you've got the all 9 justices of the Supreme Court oppose cameras in the court. Canada, which is not all that different from us. I mean, they televise all their Supreme Court hearings. So, and then there's this, right throughout the federal judiciary, there's very inconsistent. Most courts do not televise. They can't televise criminal proceedings. But in California, that's the default. Everything is cameras unless you make findings. So maybe you just get thoughts from everybody about that. Pam?
Sure. So if you look at the Supreme Court, which does not want its stuff televised, I think they give 3 basic reasons why they don't want things televised or, or simulcast audio even or the like. One thing is that they think it might lead to disturbances in the courtroom because then you can make a scene in the courtroom and it can be covered elsewhere. That doesn't strike me as a particularly good argument because the Supreme Court police will take those people out. I've been in the courtroom when people have started to scream and they get about 1 peep out of them and then you can hear the very faint sound as they're dragged down the hallway outside. The second thing that they say is that it would change how the lawyers behave, that the lawyers would somehow go for the cameras. I don't think this is true. I mean, one of the things that's really striking about the Supreme Court is the whole chamber is not really bigger than this. It's probably even a little smaller. And when you're arguing, you are so close to the justices, you are totally unaware of what's happening behind you. Even if your adrenaline wasn't keeping you focused on the justices, you can't hear the fact that people are being brought in every 3 minutes. There's a part of the public section called the 3-minute line where people get to come in, they watch 3 minutes of argument and they go out. So during the course of your 30-minute argument, 8 or 9 of these groups have come in and out. You're totally unaware of that. So the idea that lawyers who are trying to win a case in front of the Supreme Court will all of a sudden turn around as if, to break the third wall and say, like that, that's not going to happen. I actually think one of the major reasons why the justices do this, and it makes less sense now than it used to, is they don't want to be recognized when they're out in public. And one of the things that this does is it means that justices can walk out of the courthouse in the afternoon, walk around the courthouse and come back in and nobody notices they're there. And if they were televised, they think they would be more noticed. I mean, a lot of the justices are out there giving lots of interviews, making lots of writing books and the like. And so they are media presences now. So I actually don't think it would have that effect. But I think they just have this sense that somehow it would change the dynamic in the courtroom. And I don't think it would. I mean, where I do worry about this is when you have actual lay people participating. So trials seem to me to be an area that, or where you have jurors sitting in the courtroom. That seems to me to be an area where you have people who really aren't public servants in the long run a lot of times. And maybe they deserve to have a certain level of obscurity that having these little snippets of them available to be used in whatever way people use snippets, maybe not so good.
Well, I think that's a really good distinction because I remember watching the OJ trial in bits and pieces on TV news and thinking, how could you have an opinion about this? You didn't see the whole evidence, and I never did have a strong opinion. I mean, I had some thoughts in response to the snippets, but it just struck me as problematic. But I also think that, as having argued in the California Supreme Court on video and having our own court on video, I don't think it changes the dynamic. I really don't. I mean, maybe in a case as notorious, famous, whatever, as the marriage equality cases, the justices are a little more prepared in the way they're going to ask their questions than they would be if it's not going to be widely watched. But basically, they're videotaped every time. And when you're the advocate, you completely forget. The camera's not going to help you. You have to have a conversation with those justices. And I never remembered I was on camera after about the first 2 seconds. So I think there's a difference. I think you're right, between the trial court level, where it's about really, you don't want juries criticized by people who haven't heard all the evidence and seen every piece of it. And I suppose you could broadcast the whole thing, but the trouble is that news is going to be sliced up. I think there's much less risk at the Court of Appeal or the Supreme Court that some question and answer that gets taken out of context is somehow going to be a story that really changes the dynamic, the way that people fear.
Of course, I think everything should be, they should all be televised. I mean, during the O.J. Simpson trial, I was working, I couldn't watch the whole thing, but there were people, reporters who'd watched it gavel to gavel, saw the entire thing, and were not surprised by the verdict because they had seen the evidence that was presented. I cover the California Supreme Court from out of state sometimes. I cover oral arguments, or the Ninth Circuit. I think people get a better sense of the justice system, you know, and instead of all the law and order shows on TV, to see it clearly what an oral argument looks like or what a trial looks like. I think it's a good idea. I think it's educational. And, you know, they can guard jurors. OJ, we never saw the jurors, right? We never saw their identity.
And it's the one situation in which the public gets to see the courts in action and understand. You know, most of the time, you're behind the scenes if you're not a trial judge. You're behind the scenes and nobody sees how you do your work or what it's about. And that situation is one that the public can glean something about how the system works and what judges do.
You know, I think even in the trial court, depending on what the circumstances are, so, you know, just to mention Judge Robart again, I mean, it didn't stop him from getting the hate mail, but he televised his entire hearing. And, you know, I think it was brilliant. I mean, if you just look at it, I mean, here's this very calm, deliberate, you know, asking questions, really listening. So, I mean, you might be disposed to think what you're going to think, but I mean, there's nothing about that video that hurt him.
Right.
I mean, it could only help. And, you know, when I did the lethal injection case, I mean, obviously we couldn't televise it, but when we went to San Quentin to look at the execution chamber, we had cameras.
Right.
And I think that left an impression, I like to think anyway, well, this is a serious inquiry, you know? Mm-hmm. You know, you can have your own opinion as to whether it ended up the way you would have wanted it to end up, but at least it wasn't somebody just kind of going off and saying, well, I don't like the death penalty, you know? So, right. So I think cameras can be our friend if they're used thoughtfully.
Well, that was the thing about the marriage equality cases, was when the U.S. Supreme Court shut down showing the trial even on closed circuit
That thing
TV.
hasn't even been released yet.
Yeah.
Yeah.
Well,
And that was the most amazing trial to watch.
Yeah.
That was an incredible trial.
Walker wasn't afraid of it, but it also wasn't a jury trial. And so I think it would have been fine to have the video available, but, you know, I have a slight bias.
Yeah.
There were people live blogging it, you know, so you could kind of
Yes.
watch it online or read it online.
And twittering it.
And twittering
all the
it.
above.
Yeah.
Yeah.
Robin, how much time do we have?
We still have another 20 minutes.
Oh, okay. Well, so I'd like to get some questions, but is there anything that anybody wants to say they haven't had a chance to say up to now?
Well, I think the one thing is that a lot of the, you know, in addition to the changes in the media driving a lot of what's going on, the other thing that's driving a lot of what's going on is we are in an increasingly polarized country. That I think it would have been very hard to talk about, you know, Ford judges versus Carter judges in quite the same way that you hear people talking about Obama judges versus Trump judges, because we're just in a much more polarized country today, and the result of that polarization is a distrust of every government institution. And the courts are probably the last one with, with a modicum of support. But that support is vulnerable to the fact that things are very, very polarized. And the one place where you see this a little bit is some of the most politicized judges start writing for the media. That is, they're writing for Maura to get the great quote out of the opinion, rather than writing opinions that are designed to explain to the parties and to a higher court if it's a case that's likely to be appealed.
But you said one thing, which I totally understand, which is that the people are more polarized, but I also think the appointing presidents are more polarized and have been appointing judges whose backgrounds are more, it used to be that judges appointed to the federal bench were kind of middle of the road on either side. You wanted somebody who could be respected by people and felt fair. And now, when the Chief Justice said what he said about there's no Obama judges and no Trump judges, there was a part of me that was like, oh, really? It's hard for people it's not just that they're kind of being distrustful because they disagree with the other side. It's like, what kind of people are getting put on the bench?
Well, I actually think this is one that's somewhat asymmetric, because I don't think there is on the left, I don't think you could point to anybody that President Obama appointed to the federal judiciary who's as far to the left as some of the people that President Trump has nominated are to the right, because those people are not part of the Democratic legal establishment. Right. But I do think that it's, today, there are lots of people who've been nominated for judgeships in the past where you could imagine them being nominated by either party. Mm-hmm. Right. That's not as true today as it is, and I think that's a problem. But I don't think that's a problem that the judiciary has any way of solving.
No, that's a political problem.
Yeah.
I mean, and my people who know me know that I'm always optimistic. I mean, in teaching baby judges, which I still do, I think even as between the Obama and the Trump administrations, at the trial level,
yeah,
there's a lot of similarities. They're good lawyers. They're they understand what a judge does as opposed to what an advocate does or a politician does. Not everybody, but I mean, that was true in both sides. I mean, I think, I worry.
The Court of Appeals.
But the circuit judges, I worry more because I think there's more of an intention to put people on the circuit court. And this was true in Democratic administrations as well because of their philosophy. But I agree with you that it's asymmetrical. It's not, at least in my experience, there's more purpose on one side than on the other, at least recently. I mean, if you went back to President Carter's appointees, you could find some examples. But I mean, that was a long time ago.
I've received some criticism because in my Ninth Circuit stories, I always point out which president appointed which judge. But as a reader, I want to know that because it is useful. I mean, it's not as all these people, you can't predict, definitely how a panel will go, but knowing which judge appointed which president appointed each judge is helpful.
Well, in theory, if there were no Trump judges or Obama judges, it wouldn't matter, and it would teach the public that it doesn't matter. And by the way, for the vast, vast majority of cases, it doesn't matter. But it's the more cases that have more political views about the subject that
And those are the ones that get the news coverage.
Right.
Because it's, I don't know.
Not only, though.
Yeah.
Like you think about this Persky thing. Yes, the issue was a sort of hot issue, but it wasn't even it was the left screaming to hang him,
No, you're right. And I think he was done in by the left. I mean,
Right.
if you want, in terms of break the vote down. All right, questions? Yes.
Sure. Here's another case that was a very local case.
Can we ask you to stand up and
Yeah.
speak loudly? And for people, perhaps you guys can repeat the question.
Sure.
To make sure that everyone
Yeah,
hears.
thanks, Robert. We will.
So I just wanted to hear you guys discuss a little bit about the Zarate case. And that was the case where the immigrant had killed the young lady out of the dock.
Oh, that's
Yeah.
And how, in that case, that was a case of the left screaming not to hang him, but probably to protect him because he's an immigrant. San Francisco is a sanctuary city, and it was a jury trial. So just if you have any impressions or discussion.
All right, so this is the shooting, the accidental, was deemed to be an accidental death on
Yes.
what, Pier 39 or some, yeah.
Correct. Yeah,
So
Kate Steinle.
Steinle was the name of the victim.
Very
Yeah,
sympathetic,
yeah.
obviously.
And so, thoughts about that in terms of what we've been talking about?
Well, what I know about it is that the judge on the Court of Appeal who wrote the opinion, and now I'm trying to remember, it just came out recently, and I forget if it reversed or affirmed, but it basically, it reversed. And got death threats within the first couple weeks. And it's highly contentious. But on the other hand, the evidence, the gun was shot at the ground and it was a ricochet. You know, I thought it was actually pretty well covered in the media in terms of both sides. I mean, maybe it was one-sided, but it certainly more of the facts came out than often do in situations like this.
Reading the coverage from a distance, it seemed to me that media did make an effort to be balanced, but it was sort of an example of the tribalism we've been talking about. Right. You know, that a certain number of people, as soon as they see that he's an immigrant, he can do no wrong. And
you mean no right?
No.
Oh,
no wrong. And then another group of people, because he's an immigrant, he can do no right. Right. So I mean, there's
the Kentucky press
yeah.
and the San Francisco press.
Yeah, I mean, but there is. I mean, it's like you say a fact about somebody, and that immediately evokes.
Right.
Well, and it's a fact totally orthogonal to the
Right.
issue.
Right.
Right.
Which is whether there was a criminal.
Right, yeah.
Whether there was a crime.
Yeah.
Good case. Yeah.
So I work for a transparency organization that tries to gather information about federal courts and state courts. And what we run into a lot is that the judicial branch is just most, it's very, very hard to get any information. There are policies that it's created for itself in 1995, again in 2003, that judges and the names of judges can't be associated with statistical databases. So you'll have a beautiful database, no judge names. That makes it really hard for researchers, makes it hard for the press, makes it hard for Americans, right, to understand what's happening. There's no FOIA. So I wonder what you guys have to think about transparency and access to information and sort of the secret way that a lot of this happens, you know, behind closed doors.
That's a great question, and I'll just paraphrase it, and please, you know, correct me if I leave anything out. But the premise of the question is that the judiciary, at least at the federal level, is protecting its own interests in terms of how it regulates the flow of information. So you can't get judge names associated with case data if you're sort of trying to look at things like sentencing patterns or other things like that. You know, it's pretrial release. I mean, there's a whole bunch of different metrics, and that's done on purpose. And there are other ways that it's hard for researchers to get certain data from PACER, which is the federal data system. And it's a larger perception that the judiciary looks inward rather than looking at transparency and public as a way to build public trust and confidence. It's interesting. I mean, now that I have First Amendment rights, I am going to agree with you more than I would have before I had them. I think it is an issue that the judiciary needs to wrestle with. And I think there's some truth in what you say. And I'm not sure what the answer is, because see, what you would get in the response is there was a study done at Syracuse, I think, based on some partial data showing judges' sentencing proclivities, and some people ran with it and some people did. It wasn't very good data. It was partial data, and I think it was the Dallas Morning News ran a front page story saying, here are the 12 district judges in the Northern District of Texas, and the toughest judge is Judge X, you know, and the most lenient judge is Judge Y, you know, and it was, I mean, I got to say, I just was horrified when I saw that. And I think it's things like that cause the kind of protectiveness and caution that you're talking about. I think the balance needs to be adjusted, but anyway, that's my take on it.
So Maura, have you tried to ever get data like that? I mean, have you run into that frustration?
I'm actually in the process of trying to get that data
Yeah.
now.
Yeah,
On trial judges?
No, actually on the Ninth Circuit.
on the Ninth Circuit. So anything you want to say about it, or?
You know, I'm hoping I'm going to get it. I'm
Yeah.
just hoping I did. But, you know, it has been difficult to get information out of
yeah.
courts. It's very difficult.
It's it's a self.
I think the judges need to talk to us more. I mean, I have been doing this a long time, and I do talk to judges. Hugely helpful. The California Supreme Court, there are only 7 of them, though, and they know me. The Ninth Circuit, many more judges. And it's invaluable to be able to talk to them, to know them as human beings, not just people in black robes, and to learn more about the culture they're in and the environment they're in.
You know, I think part of it, though, is the ethical rules are so limiting in what judges can talk about that probably a lot of judges are afraid to talk to you about things they could talk to you about because you're afraid you're going to overstep or make a mistake.
Pending cases.
Pending cases in any court,
In any
anywhere.
court, yes, I know
you can't
that.
do
Yeah.
anything to advocate or to even try to assist lawyers who are your friends in strategy. You can't practice law. There's a lot of traps for the unwary. And as somebody who's relatively new to the bench,
You're right, Terry.
it's scary.
It is
It's
scary.
like, and I'm like really
And I guess
at risk.
this is going to sound like a cop-out, but I think you're both right. I mean, I think judges need to be cautious. I mean, the canons require you to be, and for all the reasons you say. And if you don't talk to reporters and have the kind of so I mean, I'll just name one. I mean, Howard Mintz, who was my friend for many years. Now he's gone over.
My friend too.
Gone over to the dark side and works for a law firm. But I mean, he was the legal reporter for the Mercury News for a really long time. I mean, we would just have lunch every so often, and we would just talk about stuff, and he knew that he couldn't. I wasn't going to comment.
That's exactly. I know that.
yeah,
and if
yeah,
he
yeah.
accidentally said something, I'm not going to.
Yeah.
That's not the story anyway. It's
Yeah.
My sense is that over time, the younger judges will get that and will be more comfortable.
The more experienced judges have been the best.
Is that right?
honestly, Yeah.
Which probably means they've really internalized what they can and can't do, and so they're not as worried. But I also think you've got a lot of judges, like on our court, for example, who have been in the political world, who have, like Humes and Brown and all these appointees. And so they're a little more practical and a little less sort of what might be considered ivory tower. It's just making sure that, they're cautious at first. And I'm
So
sort
the
of
caution is, you don't ever want to lose the caution. But you as you develop a relationship with somebody,
Exactly.
And
I'm talking a beat reporter who
yeah,
you see
yeah.
day in and day out.
But I think the questioner is also asking about something else, which is big data in
Right,
courts.
that's true.
And the problem there is, first of all, do not underestimate just how bad the data systems of the federal government are. That is, some of it may be by design and some of it is by sheer incompetence. And I know this from having to try and match try to show, I worked on a case when I was at DOJ that involved the question of how many registered voters in Texas lacked currently valid government-issued photo IDs. And you would not believe how many cabinet-to-cabinet meetings we had to have to get the various data systems inside the federal government to talk to one another. So some of it is incompetence and budget constraints. Some of it is the fact that judges generally, at least in my experience, they went to law school because they didn't like math. In part. And some of what goes on with databases and understanding algorithmic thinking and the like is just alien to a large generation of people who need to have this explained to them, which is one of the reasons why, for example, it's so troubling now that you have a lot of bail decisions in some states and sentencing decisions in some states being made on the basis of algorithms that the judges do not know what's going into the algorithm because it's a proprietary algorithm that a private company has put out there. And so, the judge thinks that he or she is making the decision based on, data that they've been provided, but they have no idea what's behind that data. And so some of this, I think, is really a question about the unwillingness of the federal government to put together databases in a form that are useful to a lot of people who want to do, data-based stuff. That is, you're not talking about the transparency of going to talk to a particular judge. What you want is something that tells you for every judge with every parole revocation hearing that the judge heard in the last 5 years, did they go above the guidelines? Did they go below the guidelines? And the like. And that data, I don't know that they're collecting it even in a useful form.
No, they're not, and they won't.
Because they don't want to know?
Because they don't want to have
It's
things,
used.
they don't want to have it used in a way that they think would be harmful.
Well, I mean, I think the counter argument to providing it would be, look, in the absence of knowing the facts of the case, knowing how many bails I granted for this amount doesn't mean anything and can be misused. So that's my guess as to what.
Well, that's it. I mean, it's kind of the same reason why they don't want cameras in the Supreme Court. I mean, they're afraid things are going to be taken out of context and misused. And I think,
it is.
I mean, this is a legitimate concern. I don't think, to respond to the earlier question, I don't think it justifies the complete lack of transparency in some areas. I think there's a better balance to be struck, but I think that's what the worry is.
I mean, PACER, I don't want to,
Yeah.
because there might be somebody here who has something to do with it in some ways, but wow.
Yeah.
Just wow.
Well, I think if you asked the Northern District judges who were here about PACER, they would probably agree with you. So.
There's another question.
Yeah. Go ahead. Yeah.
I'll ask a more pointed version of this question.
Yeah, okay.
So I think even if the data is bad now, there's so many private companies working to make good data, link data to judges. So transparency isn't a question of if, it's a question of when.
And how.
And I think a big question is how the judiciary, is going to face transparency in whatever form it comes in, and how that links to balancing judicial independence with this transparency, this information potentially, and there potentially being bad patterns coming out of that transparency, and how we, do want the public to trust the judiciary, and if there are legitimate instances of bad behavior in the judiciary, how do we retain trust of the public in the judiciary and the legal profession? Out of that, because we've got all major corporations, doing unconscious bias training now. We have judicial decisions judging corporate programs on the basis of disparate impact coming out of those programs. So if disparate impact comes out of the judiciary from this data. So my question is, where do I think civics lessons are great. I think having videos of oral arguments are great, but this data is going to be out there. Someone's going to be using it. Like the judiciary, whether or not they know algorithms or not.
I think that's. I'm not going to argue with you. I mean, I think you're right. I think it's just it's how you do it. It's how you do it. I mean, right now some of the uses of big data are a little funky. I mean, when I was still sitting, I would say that I would have somebody writing me a brief and saying, well, in these 5 cases you granted a continuance of a case management conference. Really? I mean, that's supposed to get you something? I mean, but they had kind of gotten trivial like that. Whereas the point you're making is it's much more. You really, if you see patterns and you can notice that people are behaving in ways that are that reflect unconscious biases, that reflect patterns that are troubling. I think in the end it's going to build confidence in the judiciary to have that kind of transparency. I think that's the larger point. I agree with you. Anyone else want to?
Yeah, I think you're right, and I think that one thing that courts can do is decide what data they're going to include. So if people are asking about data about a certain type of decision, what else is potentially relevant that can be put in a big data kind of format to give some context? But you're right; the judges, the judiciary have to grapple with it, or it will get grappled with without their input. So you're right about that.
There used to be a professor who at Santa Clara University who's since retired, and he would put out something in California Lawyer magazine of the different justices on the California Supreme Court.
Ullman,
Yeah, Jerry Ullman. How many decisions each had, what were the blockbusters, what now. And when I went to the court not that long ago to get counts, they said that that's not public, which is ridiculous. I mean, and I think I eventually got this, I think I eventually got something. But I'm not going to say because somebody only had 6 opinions and somebody had 12 that the person who wrote 6 opinions is lazy. I mean, I wouldn't want somebody to say that about my stories, that I had only, 24 instead of 58. It's life.
And
It's
yours were
different.
good, and theirs
Yeah, right. But we have to have that information. I mean, that's one of the things, only one. I don't make a huge deal about it, but when I do a profile of a judge, that is one of the things I look at.
Well, we're out of time. Robin, do you want to wrap up?
Yes, I just wanted to have everybody thank our panel, please. And in addition to our wonderful panel, I'd like to also just take a moment to thank those whose work made today possible, including Mary Hoops of the Berkeley Judicial Institute, the court staff, and especially Bradley Vandehay and Sam Gerard, and our wonderful volunteers, Emma Rotem and Olivia, our MCLE sponsor, Farrell, LeBron, and Martel. Thanks very much to their staff, and our brand new assistant to the director, Scarlett. And now, without further ado, please join us around the corner in the great hallway for drinks and appetizers. Thank you all so much for being here.
It was good.
Well, because